Well, it is 2 o'clock. Some of you have been here for a half hour already. It's wonderful to see all of you, and we'll be joined by more because we had over 100 people sign up to hear Julie today. So welcome on this beautifully sunny day. This is our second program with sponsorship by both Helping Hands University Park and HAP, Hyattsville Aging in Place, on legal issues related to aging, which we are all doing beautifully, as I can see. Jennifer Brandy presented last October on planning for long-term care, and today we are so happy to have Julie Schejbal presenting on the drama of aging. In introducing Julie, Julie, I hope your parents are here.
I think they are.
Okay.
Good, bad, or indifferent.
Okay. I want to begin by honoring her parents' wishes to say that Julie is a proud product of Prince George's County Public Schools, having graduated from University Park Elementary, Hyattsville Middle School, and Northwestern High School. And then University of Maryland before going on to Duke for law school. So let's hear it for Prince George's County Public Schools. Prior to opening her private practice, Julie worked for the IRS, let's hear it for the IRS, in the Estate and Tax Division. Her practice concentrates in the areas of estate planning, elder law, estate administration, and taxation. Her office, as you'll see when she goes through her presentation, is in Dunkirk. But back in normal times, I'm not sure what Julie's doing right now. Back in normal times, she met with clients in their homes in this area, which makes things very easy. A few comments before I turn this over to Julie. Everybody is muted, except for Julie and me at the moment. This program is being recorded, so if you're uncomfortable with that, it is also being live streamed to the Helping Hands University Park Facebook page, or you can hide yourself. And after the program, once it's edited by Carter Ross, it will be posted on the Hyattsville Aging in Place website and on the Helping Hands website. A bunch of questions have already been sent in, and Julie will be answering those during the Q&A. You will also have a chance to ask questions at the end of Julie's presentation. As they come to you, feel free to put them in the chat and direct them to Lisa Walker, who is one of the hosts, so her name hopefully shows up at the top of your list. I think that is all, and let me turn it over at this point to Julie.
Good afternoon, everyone, and thank you for coming. I really appreciate the large turnout. This is really unbelievable. The other thing that I'd like to talk about before I start is that two things. COVID obviously is important, and it's out there on everybody's mind, but I'm not really going to talk about it so much because, in my view, these things really didn't change because of COVID. COVID may have made them more imperative to have things in place, but it really hasn't changed the underlying need for these documents. We would be having a very similar discussion in 2019 and hopefully later this year in 2022. The other thing is that this may be a little different. I'm trying something new, and I'm not using you guys as guinea pigs as much as I was trying to ramp up maybe the entertainment value or something. And so a lot of this is going to be to avoid the dryness of talking about wills and trusts, which I'm going to do, but also I'm going to talk about, sort of relay it in stories that I have seen happen in my practice that I think will underscore the need to put things in place so that you can see, okay, this is what can go wrong. And let me tell you that, it's like anything else, what can go wrong will go wrong, and then even more. So that's, just the nature of things. And the reason I sort of entitled it The Drama of Aging is that people die, people lose capacity, whatever that looks like, and their kids act like crazy people. Even if they were sane, they become insane. And so now these documents will not avoid that. As I always say in my practice, if I could create, I think I draft pretty well, I can't draft family harmony. But let me tell you, once I find the key to unlocking that, I will no longer have to do this, and I will no longer have to practice. because I'm going to trademark that, and then I'm going to move into my fat villa in Jamaica, because it's just, I mean, that's how, you know, everybody wants to unlock that secret, right? So that's just the way it is. But, you know, we're going to try to do things that will minimize this. And I also want to thank Loretta for all of the graphics on the slides. This is all her, and I really, really appreciate it. As I like to say, I'm an attorney with a tax background, which makes me one of the most boring people on earth. So anything that's creative is all Loretta. So basically what I'm going to talk about today is I'm going to play it down into about 2 basic periods, or, you know, basic things or acts. So the first part is we're going to talk about the estate planning basics, the documents you should have in place that will help you smooth out all of these things. The second part is I'm really going to relay stories about what happens if you don't plan. Okay, this is where you're really going to, you know, what happens if you fail to do this. And then the last part would be sort of talking about tips for the caregivers or the representatives, because I've also seen that if these things blow up, and then somebody comes into my office and after the fact, and I'm like, man, if we'd only gotten them in here 2 years earlier, maybe we could have laid some defensive tips or groundworks to avoid some of this. And then after the fact, it's too late, and we're trying to put Humpty together again, and that type of thing. So basically, there are 2 types of drama that you're going to have. You're going to have their family feuds is the basic thing. So let's say this: if your kids do not get along now, they are not going to get along after you die. That's a given. So, and hopefully they get along, but it can happen. And so there's the post-death trauma or drama that happens during probate. And then there's the lifetime drama that happens as people, mom and dad, get older, they lose their capacity, and the kids are, you know, trying to care for them or do whatever for them. I mean, in fact, I used to have a cartoon in my office, and it was about 3 kids sitting around the table, and they were all in their like 50s, and they're saying, well, we need to create a plan for mom's care. One of us will do all of the work, the other one will do nothing, and the third one will just try to blow everything up that we do. So it's sort of, you know, that's the, and I thought this is the most perfect cartoon ever. So what is estate planning? So estate planning is basically a method of transferring your assets or your wealth to your next generation, or to where you want it to go, the objects of your bounty. That could be if you have children, it may be your children. It may be if you have no children, or you have children and you dislike what they're doing, it may be to a charity. It might be to friends. It's basically setting up this. This is where I want my money and property to go when I die. It's also, maybe equally important or more important, is to create a method for dealing with your incapacity while you're alive. What happens if I lose my marbles? Who's going to take care of my money? Who's going to make decisions about my health? And these are all things that you need to have in place. So the other thing I talk about is that people will say to me, well, I don't have very much. I don't need a will. Well, wealth can be deceiving. If you have life insurance, that's part of your wealth calculation. If you have IRAs or retirement money, that's also part of your wealth calculation. And I always term these assets what I call stealth wealth assets. And that's because for people before you're 72, your retirement money, or 59 and a half rather, you can't spend it, or you can't spend it without a penalty, or your insurance is simply a piece of paper. But when you die, all of this money and property is on the table. So the insurance money that you couldn't use to go to the movies or buy a beach house is available to your children. The other, and then it's also, these things are distributed when you die, so it's going to augment or increase your wealth. Now, I realize for a lot of people on this call, there may not be a lot of life insurance because your kids are grown and you may have kicked that to the curb as an expense you don't need, which is terrific, but you still may be looking at balances in your IRAs and retirement money. So everybody wants to know about tax or death tax. So it's changed a lot. I am old enough that when I started, the federal estate tax limit was $600,000. So When I worked at IRS, that's what the limit was. And I used to say I would steal money from rich widows and orphans. Now I help them keep it. But what, and it's gone through different iterations over the years. But right now, a single individual can exempt $11,700,000 from federal estate tax. So there will be no tax imposed on your estate till you get over that limit. A married couple can exempt $23,400,000. So it's pretty generous right now. This was as of January 1st. Maryland has a lower exemption. They're going to tax your assets when you get over $5 million. So if there's anybody out there with more than $5 million worth of wealth, we really are going to look at that from a planning standpoint. If you're less than 5 million, you really don't have to worry about that. Now, the one thing that may put a wrinkle in it, as of January 20th, we have a new administration. I don't know what President Biden is going to do about the estate tax. So we want to, we want to keep an eye on that, because if he lowers the exemptions, the thresholds, then, people who were previously not subject to tax may be subject to tax. So it's always a good idea to keep an eye on that, because you don't want to try to avoid tax at all costs, or all legitimate costs, by the way. Let me back up one thing. The other thing that Maryland has, and I think somebody asked this question, Maryland does impose inheritance tax. An inheritance tax is different from estate tax. Estate tax is based on a number or threshold. If you're at $5 million or less than 5 million, you don't pay estate tax. If you're over 5 million, you pay estate tax to Maryland. But in an inheritance tax, the difference is it is based on your relationship between the dead person and the person inheriting. So Maryland right now imposes a 10% inheritance tax on money and property going to nieces and nephews, cousins, friends, and anybody else who would be wider than that. So basically, if your money and property is going to anybody besides spouses, children, or brothers and sisters. And it's really hard to do anything about that because it's based on a relationship. So a couple of years ago, I was redoing some stuff, and I talked to my sisters, because I don't have children. I said to them, I need your social security numbers because I'm redoing some things, and I'm redoing beneficiaries and whatever. And I said to them in the same breath I would prefer that this money not go to you all. I would prefer it go to your children, my nieces and nephews, but they would pay 10% inheritance tax, and I can't stomach that, so I'm sending it to you guys. One sister wrote back and said, come on, Julie, this is what you do. Can't you figure out a way around it? And I wrote back to her and I said, yes, the only way I've figured out a way around it is to adopt your children, which I do not want to do. The other one said, that's okay. They have enough money. I'm like, all right, whatever. But that's the thing. It's very difficult to change that relationship because it's based on that. So now the other thing to talk about is estate planning is not impacted by wealth. There are concerns that no matter how much money or property you have are concerns for everybody. Incapacity. What happens if you lose your marbles? Transferring your assets to your children. I mean, regardless of how much you would like to make that a smoother transition. Now, your children may prefer that there were more wealth, but I can't do anything about that. In my office, I have a picture of Prague in the Czech Republic, and sometimes people, when I'm doing probate for their, as a result of parents' death, they'll come in and go, well, how come I didn't get more money? And I'll say two things. Well, one, your parents should have worked harder. And two, see that picture up there? That's a picture of Prague. That's where my dad's from. And in that city, people tried desperately in the 13th and 14th century to turn lead into gold. They couldn't do it. Now, do you think if my people couldn't do that, I would be turning your parents' lead into gold? So there's, that we can't do anything about it. But again, going back to the theme of today, the other prong is to try to avoid or reduce drama. Now, what is impacted by wealth is possibly the complexity of your estate plan. Kind of hit on taxes previously. If you were over those thresholds, your plan is going to be more complex because we're going to be looking at ways to reduce the taxes. And for all of you on this call today or the Zoom session today, we're not really going to touch on that. So you're going to be happy to avoid all of the tediousness that goes with that. But it is something to keep an eye on. Now, what is the number one thing you can do to prevent drama, or what is the number one cause? It's procrastination. It's like anything else in life. If you procrastinate, it's going to be a problem. And how can procrastination become a problem? Well, two things. One, you can die and then it's too late to do any of this, or you can lose capacity and it's also too late to do any of this. So this is sort of like, get motivated and start doing things. Now, there are basically, when I talk about estate planning, I talk about the big three or the big four. And what they are estate planning documents. So basically, a well-rounded plan will at least have a will, a financial power of attorney, and a medical directive. And what makes up the big four is we add a revocable or living trust to that plan. So you're going to look at least 3 out of the 4 documents will make a good solid plan. So what is a will? Basically, when you're doing your will, you're creating a plan or a method to transfer your assets after death. Maybe this is to your children. Maybe this is to other family members, to a partner. Oh, because by the way, if you have a partner, you're unmarried. I'm not judging. I don't care. As long as you don't hurt children or dogs, I really don't care what anybody does. But here's the thing: if you don't have a will and you have a partner, you know how much money that partner gets when you die? If it's in your own name, the same amount that I'm going to get from your estate, which is 0. So it's very imperative to do that. I mean, in fact, right now I'm dealing with probate for somebody. I'm helping the dad. His son died, and the son had a long-term relationship with his girlfriend or partner. They didn't have a will. They had nothing. And so basically all of the wealth is going to dad and none to the girlfriend. And the girlfriend's got a lawyer, and we keep saying, well, why didn't they do anything? And the other lawyer actually asked the girlfriend the other day, and she said, why didn't you do anything? And she goes, well, we never got around to it. And both of us are like, yeah, and you're going to reap what you sow in that case. So, that's really, again, I can't stress how important that is. Maybe you want to go to friends. You don't have any family. Friends, charity. All of those things are available to you, but if you don't do a will, the state of Maryland is going to take care of that. And what the state of Maryland is going to do is they're going to say it's going to look at the family tree. So if you have children, it'll go to your children. If you have no children, it'll go to brothers and sisters. If you don't have brothers and sisters, nieces and nephews, and then it's going to start going out along those lines of cousins and people like that on your family tree, people you see at weddings and funerals. If you don't have anybody, it will end up with the Board of Education for Prince George's County. So as Loretta mentioned, I'm a graduate of Prince George's County Public Schools. My mother taught in Prince George's County Public Schools. So it really doesn't bother me that the money goes to the public school system. But for clients who sent their children to private school or to school in Montgomery County or Howard or wherever or some other county, it kind of frosts them. So, you might, if this is a problem, you want to, concern, you want to avoid that. And again, we talked about the big 3. So there are 2 other documents that are, when we talked about the big 3, the financial power of attorney. And what that does is it appoints somebody to handle your financial affairs in the event of your incapacity. So they can file taxes, pay bills, sell property, argue about bills, sue, anything you could do financially, they can do for you. The second document is an advanced medical directive. So that has 3 parts right now. The first part is you're going to appoint a healthcare agent to make medical decisions for you. So that person can make decisions about, the most dramatic ones, pulling the plug, but it also can they can also make decisions about, look, mom or dad has dementia, they fell out of bed, they broke their ankle, then that person can talk to the doctor about surgery or physical therapy or all of those things that go along with that, which is falling out of bed, breaking your ankle is certainly not a life-ending event. And then the other thing you're able to do with the directive is to say, this is the kind of healthcare treatment I want when I'm at the end of my life. I want no medical intervention, including no feeding tube, or no medical intervention but a feeding tube, or keep me alive at all costs. You're able to make these representations, and it's a very clear representation about what you want, because like I tell people all the time, look, if you have this document, it really goes a long way to making sure that your children or whoever's making these decisions won't, try to go against your wishes. Because like I say, look, if you fill it out and one of your kids says, no, I don't want this, I can go into court and say, well, look, this is what dad or mom wanted, pointing to the document which was witnessed, to say this is what they wanted. Now, I'm not very good at litigating, but I think I can win that case because it's very clear. The other thing you can opt out of on this one is pain medication. If you want to, you really want to suffer at the end of your life, or you're afraid you didn't score enough points on earth, you're able to do that. Now, the third document on this slide is a MOLST form, and that stands for Maryland Orders on Life-Sustaining Treatment. So this is a fairly new document. Now, first, I want to stress, this does not come from your attorney. This is only executed with the advice and supervision of your physician. And what it is doing is it expands the breadth and width of the power of attorney, at the medical directive, in terms of withholding life support. So if you were to read a medical directive, you would know that life support is only going to be withheld when you're at the very end. Your death from a terminal condition is imminent, or you're in a permanent coma with no hope of recovery. So you're, as I like to say, cooked. But what the MOLST kind of recognizes is that there are times when the health diagnosis, we're going to end up there. We're going to end up with no capacity and maybe in a vegetative state or in a terminal condition. And, we don't necessarily want to go through that all the time. Like the classic one for me is dementia. What do we know about dementia? It's incurable. You can be physically healthy for a very long time, and it gets worse and worse and worse. So what the MOLST would allow you to do is to say, look, if I'm diagnosed with dementia and I have an intervening medical event like a heart attack, I don't care how healthy I am. Do not resuscitate me. Do not take medical intervention. Because essentially what you're saying is, I know I'm going to end up there, but I don't want to go through all of that till I end up there. And I can tell you two things about this. When I first learned about it, I was at a meeting at Anne Arundel Medical Center, and the director of hospice came in and she's talking about this, and she had a very powerful PowerPoint slide, because it started out with the slide of everybody, the typical hospital bed, tubes everywhere, and somebody laying there, with all the machines. And her slide was, nobody wants to end up like this. And the second slide was, well, 60% of us will, or some ridiculously high number. And everybody in the room basically could hear the eye rolls. Everybody was groaning. We don't want to end up like that, right? And so this allows that. And the other good thing about this document is that it allows you to make these decisions in a non-chaotic time. You're able to do this with your doc, and it's not, there's no concern about healthcare, immediate healthcare, or anything like that. So the story I talk about, my parents are probably going to kill me for this one, but is years ago, my mother was having her knee replaced, and she was at the pre-PT. So she's doing her PT, and she had an attack of vertigo. So she goes to the hospital to have that dealt with. Dad calls my sisters and I, were like, okay, let us know if you need anything, Pop. We're here. It's whatever. Well, my middle sister says that when her oldest daughter, who was in high school at the time, found out that her grandmother was in the hospital, she totally lost it, even though it was like non-critical, right? And all I took from that was, if you were actually in the hospital with mom or dad after they had a heart attack, when they've been diagnosed with dementia, and you've got all the siblings, the spouse, the children, maybe grandchildren, and whoever else are there, and the doctor comes out of the exam room and says, well, Dad's going to be fine. We're going to put a stent in, and he's going to be great. Nobody's thinking past that minute. They're going to say, great, do it. Then what happens is, possibly having all of this done, it exacerbates the dementia, and your parent is basically, or you are hooked up to a machine for the last 6 months of your life, and everybody's kind of going, man, I think it would have been a blessing if they had died during that heart attack. So it allows you to make these decisions. So it's sort of like, and I think somebody asked a question about end of life option and assisted suicide, which does come up periodically in Maryland for a vote or in committee. I am not sure what happened this time, but this doesn't go as far as assisted suicide. If you were to look at this on a continuum, the least aggressive one would be advanced medical directive, then this would be kind of more aggressive or more broad, but then the most aggressive one would be assisted suicide. So it's not there, but it is, you know, expanding the breadth. And what's the number 2 preventable cause of drama, which you all can control? Failure to plan. Does that old cliche go, planning to fail is failing to plan? So if you don't plan, you basically get what the state of Maryland has in store for you, which probably not going to be what you want. So here we go. I hear this a lot. I don't want to do a will. You may be telling your kids this. I don't want to do a will, or whoever, right? Well, here's the thing if you don't do a will. If you don't do a will, you die intestate. Well, what does that mean? That means that Maryland, you go to Maryland law, and it figures out how your money and property is going to be distributed. If you have children, it's going to be distributed equally among your children and outright. Sometimes this is not the best option. Maybe there's a child that unfortunately you want to disinherit. Oh, by the way, on that one, sometimes people, when they want to disinherit their kids, they come in and go, well, I don't want to give any money to Julie. I'm giving her $1. That would get rid of her, right? And I always say, look, we can do this, but I'm not putting in $1. First of all, to me, that looks like a literal slap across the face. Let's just own it. And 2, it doesn't get you anywhere anyway. So it's just, but you can disinherit them. That's not the problem, but it's just don't leave them $1. The other, when it may not always be the best option to get it outright, maybe you have a kid or children that have issues. They have gambling issues or drinking issues or drug issues, unfortunately. And, you know, you don't want to leave it to them outright. You want to do something a little more complex because you feel like you need to protect them from themselves. What if you have no children? Again, we talked about this, it's going to go to your other family members, brothers or sisters, cousins. No family, again, I talked about it's going to go to the Prince George's County Board of Education. So it's not your favorite charity if you have no family. So you've missed an opportunity for this. So that's, you know, and the other thing people sometimes talk about, they have well, I don't know what I want to do with my money. And they get wrapped around the axle about this. And I can't help you. I mean, I can't tell you what to do with your money, but I can tell you it's probably better than this plan. Even if your plan is not perfect, let's do the least imperfect plan possible. So, you know, again, if you're dissatisfied with Maryland intestacy, the only person who can change it is you, and you're dead. So what I talk about the ghost writing checks, I had this one time. A family came in, their sister had died, and they said, and I had looked at it, and one other sister was causing a fuss, and I looked through the checks, and I said, well, wait a minute, here are $70,000 worth of checks written by your sister that are dated days after she died. I don't know a lot, but I do know a ghost can't write checks. How did this happen? Well, we did what she wanted. We wrote these checks, and that's what she wanted to do. She wanted money to go to me, to Bob, to Susie, whatever. So we did this. And I said, but you can't do that. She needs to do a will. Well, she didn't want to do a will. Well, you can't write the will for her. Well, she didn't want to do the will. So, I mean, we went to court, and they ended up losing the $70,000 because, again, a ghost can't write checks. And she didn't want to do a will. She got stuck with what Maryland wanted. And so that is what it is. The other one was, I saw this when I was at IRS. This gentleman had a fairly substantial estate, and everything went to these cousins, and it was a couple $1 million. And this is back in the 90s where a couple $1 million was a lot of money. And you could tell from the return that these 2 cousins who lived on the West Coast were getting all of this money. And I talked to the attorney, and he happened to mention in passing, he said, look, I can't believe he didn't have a will. He was very involved in his church. I know that he would have given money to his church and not to these cousins. Well, that's what he got. That's what he ended up with because he didn't have a will. The money went to the people he saw at weddings and funerals, and maybe not even then because they lived on the West Coast. So, okay, and then Again, I don't need a medical directive or power of attorney. Well, here's what happens if you don't want to do that. You are going to be subject to what's called a guardianship. And what happens with that, excuse me, is Maryland is going to determine who your guardian is. And you're going to be subject to a court proceeding. It is expensive. Anytime you go to court, it is expensive. It costs you $150 just to play. And what I mean by that is when you're filing in court, you pay $150 before you pay any attorney's fees or go to court or anything else. That's your ticket, your entrance to the ticket, your ticket in. It's public. So you go to court. When we were going to court pre-COVID, you might be in a hearing room and there might be 30 or 40 other people in there with you, and your case is going forward. So if people are listening, they can hear anything that is going on. And if your neighbors know it's up and they want to snoop, they can come in. So it's time extensive. It's very extensive in terms of time. And again, let's go back to expense. Somebody's going to pay the attorney to draft all the guardianship up. They also will have to hire another attorney to determine, to be your attorney, the incapacitated person. So you're going to pay two attorneys. And the last part is, it's humiliating. Again, the court hearings are public. There may be interviews with your friends or coworkers or neighbors. There may be in the courtroom fighting between your children and other relatives. So all this dirty laundry is going to get spewed out there. And I can tell you about this because I had a case where I was doing a guardianship for a senior, and this guy was very well educated. He was employed as a professor at the University of Maryland. He had a doctorate. And what happened is he lost capacity. He didn't want to do a power of attorney. He didn't want to do a medical directive before all this happened. He knew better. And then the other thing was, when we went to do the guardianship, he retained enough capacity to say, I don't think we need it. And so his attorney said, we need a hearing. So what happened? I brought in coworkers, I brought in neighbors, and they all testified to, where this guy was, that he couldn't tell time, and he couldn't wind his watch, and, lost his car in the parking lot, and just myriad of other terrible things. And this all played out in public. And and this is going to be cynical, but the one thing I thought about it was, thank God he's not going to remember any of this, because if he did, he would really be hateful toward his friends. But it was just, but all because he refused to do this. And the number 3 preventable cause of drama is the failure to keep receipts. So what happens here is that this is particularly if you are a caregiver, and if you are, so if you're handling somebody's money, or you are taking care of mom or dad, or somebody's handling it for you, or you're talking to your kids, what happens is after they have done all of this caregiving and you die, all your other kids will come in and go, well, I don't know, I think Julie ripped mom and dad off. I don't know where all the money went. And if you don't keep receipts, you have nowhere to prove that the money went for their care or for food or anything else. It could look like it all went to Julie's pocket. So for your children who are going to keep, you're going to handle your affairs, that's sort of a preventative measure. And so again, it goes back to, I am the power of attorney. What could go wrong? Well, everything. So you want to be very, defensive about this, or you don't want to be defensive. You want to practice proactive defense. In other words, be on top of things, keep receipts. The other thing I would say about receipts, it's not enough to keep them because they fade. Unfortunately, somebody may want to scan them in, which I know is another step, which is a pain, but it is, it's vitally important. And so again, as a power of attorney, you're the fiduciary. You're supposed to act in mom's best interest or dad's best interest. If you don't do this, you're subject to civil liability, which means that for one of your children who's acting as your fiduciary, if they don't do what they're supposed to, or their siblings don't think they did what they were supposed to, they can sue them, And then they may end up paying back all of that money. And this can be, you know, even if there isn't, even if you're acting in someone's best interest and you know you're doing this, you're acting in good faith, you're not going to not face civil liability, but there could be family tension. So it is like, you know, you just have to be on the lookout for that, or aware of that. And again, this is under the category of no good deed goes unpunished. And you know who's going to yell the loudest? It's going to be the siblings who did nothing. They always act, you know, I always say that when somebody comes in my office after a parent dies, I have yet to hear anybody say, I was not the good kid. I did not visit mom or dad. I didn't help with the groceries. I didn't do anything. I don't deserve any of mom or dad's money. The day I hear that, I'm going to fall out of my chair. I'm pretty sure I'm going to retire and never hear that. But they always believe that the agent is stealing mom or dad's money. And I mean, it's amazing to me because it also happens like if a parent unfortunately has ended up in a nursing home, and nursing homes are expensive. We all know that, or I think we all know that. But you'd be surprised when a parent dies and they've been in a nursing home, the other siblings are like, where'd all the money go? And I'm like, well, it's $10,000 a month, $11,000 a month. Where do you think it went? Well, it's, you know, there should be more money here. And so it's, you know, really, whoever's going to be your caregiver needs to be cognizant of that. And so, like, again, in the case of the devoted daughter, I had clients who, they failed to keep receipts, which is why they're on this list. But basically, their goal was to keep their mother out of the nursing home. So they did everything they could. Daughter would come over, check on mom. And it was not you know, mom didn't live next door. This was like a 30-mile commute for the daughter. She would check on her, bring mom food, often would stop by like a local McDonald's or Popeyes or something and grab mom food and bring it to mom and, you know, check on mom. And she would do this, you know, a lot, like for 2 or 3 years. And money went again for mom's care. Mom died. The other siblings who didn't lift a finger are there going, well, where'd you spend the money? You stole all of mom and dad's money. Problem is, you guys are all going to think that all I do is back losing cases. And I really don't. These are a couple that, you know, they end up in the Hall of Fame because they are bad facts. But they didn't have any receipts. So I was like, what are we going to do? Because we don't have receipts. We're going to scrap together what we can, but it was very difficult to prove that all the money was used for mom's care because we didn't have the receipts. Another one would be the case of the helpful hand. A client of mine, he was helping a neighbor who was elderly and with her paperwork. Now, he didn't have a power of attorney, but he was helping her, you know, try to keep her on tap and paying bills and things like that. Fortunately, this guy had a background as a CPA, so he kept every receipt. But sure enough, what happened? She ends up in a nursing home. The kids now come in and they're like, well, what'd you do with all the money? Where's all the money? And, you know, he was able to produce all of these receipts, but, you know, they couldn't wait. Instead of thank you for helping mom, it was, well, where's all the money? And then the other thing is that so if you're an agent, your tips would be to seek advice from professionals, attorneys, accountants, healthcare agents, healthcare professionals. And the other thing is when you're doing this, your kids should not pay for this. This should come out of the parents' money. It's for the parents' benefit. It doesn't mean that they have to rack up huge legal fees or accounting fees doing this, but it is a good idea, I think, to spend a little bit of time, be proactive, get your ducks in a row. The other thing is communicate with the siblings or other people involved. You'll limit surprises and you'll enhance understanding about healthcare costs. So if you talk to your siblings and say, look, you know, we got to bring somebody in for mom or dad and it's going to be, you know, $100 a day, then if mom or dad passes away and they now understand where some of that money went because it was there for mom and dad's care. But if you haven't been communicating with them, if your kids don't communicate, it is going to be kind of shock and awe. And again, these are tips like keep the receipts, keep the receipts. And now this is a question I think that was raised. So if you don't have, some people will say to me, I don't have close family, what should I do? Well, again, we go back to Maryland has a plan for you. So the money and property is going to go to cousins, again, the Board of Education, and you might be subject to a guardianship. And if you're subject to a guardianship, in this case, you are really going to get hammered, for lack of a better term, because not only is Maryland going to subject to the guardianship, but you may not have a say in who should be your guardian. So even if it's, you know, you may say with power of attorney, I don't have close family, but I want my friend to do it. At least you have say over that. So, but maybe it's reaching out to family or friends, you know, and these are, and I understand if you don't have close family, this is difficult choices, but, and they're not going to be perfect, but it's probably better than the alternative. And again, you can, you know, I mean, anything's probably better than the alternative. Okay, so I'm going to talk quickly about Medicaid, and that just from this standpoint, when I talk about Medicaid to clients, I talk about the qualifications. To qualify for Medicaid, you must be both what I call broke and medically needy. Medically needy means you need assistance with the 5 activities of daily living, which are transferring, which is getting in and out of bed, dressing, toileting, showering, and feeding yourself. That's always determined by a doctor or a healthcare professional. Broke, I have not looked at I will confess, I have not looked at the levels for 2021, but in 2020, it was having less than $2,500 in your own pocket. So you're pretty much broke. So, and what Medicaid covers is long-term care. So nursing home, in-home health care sometimes. It is not Medicare. Medicare covers your health insurance. So it covers if you break your leg, or rehab if you've broken your leg and that kind of thing, but it won't cover nursing home. Well, okay, Medicare will cover nursing home if you're there for a stay as rehab. But once you're out of rehab, it doesn't cover that. And I always tell people, there are many ways to go broke in this country, or in any country, right? Giving large amounts of money to your children as the nursing home wolf is at the door is not one of those ways. So if you give money away to your kids as you think you're going to a nursing home, that's going to fail. The other thing I would say about this is that the spouse, for Medicaid or many things in law, the spouse is the favorite of the law. So what that means is that there are rules within the law of Medicaid that allow for more expansive savings of assets for the benefit of the well or community spouse. The same thing does not exist for the surviving spouse. So the methods we have to save money for the well spouse are not available to save money for your children. But the reason I bring this up is that if you are faced with, and I know this is against or not with the goal of helping hands, believe me, I don't think anybody wants to go in a nursing home. I believe you don't put people don't even want to put their worst enemy in a nursing home, but it is a reality for people. And that is, if you are faced with having to put a spouse into a nursing home, that you need to go talk to an elder law attorney, because it isn't a choice necessarily of, well, I'm going to spend all of my money to take care of Pete, my husband, and I'm going to have nothing left for me. There are ways that we can preserve that money for the community spouse. Now, I think before we do questions, I think I either skipped a couple of slides, which I apologize, or whatever, but I think I didn't. I don't remember if I talked about a revocable trust or not. So the one thing is with a revocable trust is that it is sort of the fourth prong. If you go back to when I talked about estate planning, sometimes people do the big four, and that includes a revocable or family trust. So what a trust does is, it is very much like your will. Anything you would do in your will to disperse with assets or distribute assets, you could do in your trust. But it also combines aspects of a power of attorney. So it also sets up a method for somebody to handle your assets if you lose capacity. So it's got both sort of prongs, so it's kind of a larger combined document. And somebody raised a question, I know, in the pre-questions about a trust, and is that, does Maryland believe in them? Absolutely. And what you will hear about a trust, if you were to turn on popular media today, Susie Orman screams about these things all the time, is assets in a trust avoid probate. And that is 100% correct. But they also make probate sound like it is the big bad wolf or the ogre or any other terrible monster out there. Probate is not that bad. So I rarely do trust to avoid probate. Where probate gets bad is if children fight. I can tell you if you have a trust or a will and your kids fight, it's all bad. But again, assets in a trust do avoid probate. It's 100% correct. The reason I do trusts are I believe it is the best vehicle to handle your financial assets in the event of incapacity. It does work the best. Now, the one thing about a trust is that they also, but the one thing I always will do trust for is if you own property in another jurisdiction. So you have property, you live in Maryland, you own a beach house in Delaware or Florida or wherever. If you own real property in more than one state, you're going to be subject to probate in both states. So that is going to increase your expenses. Particularly, I'm doing one in Florida right now, and Florida seems to, like the gentleman lived here in Maryland, he owned property in Florida. In Florida, they are really coming after him for money. Maryland, it doesn't seem to be. If the reverse were true, lived in Florida and owned property up here, it's not quite as bad. But anyway, you're going to have, when you die, it's going to ratchet up your costs. So you would definitely look at a trust if you own property in more than one state. But the other thing about a trust is that they aren't always equal or treated equally. All assets in a trust aren't treated equally, and you don't get as many advantages. So take somebody with $10 million in their IRA. I think we'd all agree that's a lot of money. That person would not be a good candidate for a trust. Because one, if you have a 401k or IRA, if you have a designated beneficiary, that money doesn't go through probate anyway. So you're not getting any advantage there. And two, if you put the IRA or 401k in a trust, that particular asset, the IRS, it's very tricky to do that. And if you do that, you can risk having all of that deferred income tax that we all enjoyed as we put money into that account and watched it grow become due. So I would like to avoid that risk, but they are very helpful. And I don't want you guys to leave this and say Julie doesn't do them. I do a lot of trust planning. Typically, I do the planning when we're talking about a surviving spouse, a widower, a single individual, because at that point, also all of your money and property is probably going to be subject to probate. If you're married and you guys own everything together, none of that will go through probate. So they're very helpful, but it just depends on whether somebody's a good candidate for a trust. Any questions?
I'm sorry. Yes,
Yes.
I have been, this is Lisa Walker. I've been collecting questions, and thank you very much, Julie. I think we're going to go back to the beginning of your presentation because there were a considerable number of questions about estate and inheritance taxes. So let me just go back and do that.
Cool.
First thing was, it's a $5 million per person and 10 million for a couple. That's not taxed. Is that it?
Okay, not necessarily. So the federal government, it's $23,700,000 for a married couple. Maryland, it's $5 million per individual, but you don't get the same combined treatment for that $5 million. So in other words, a married couple doesn't automatically get to, let's put it this way. If you were a married couple with $6 million worth of assets, and you did no tax planning in your wills, you would pay, upon the surviving spouse's death, there would be $160,000 paid to the state of Maryland in estate tax.
Where's that 160,000 come from?
I'm sorry, it's based on the difference. So basically it's at $1 million. So if someone had 6 million, you basically reduce it by 5 million and you pay tax on that difference. So that and it's basically a 16% tax rate.
But if you're married, I don't know. I guess you wouldn't die at the same time. Unlike
okay, so what happens is the federal government basically doubled it and said, if you're married, you can exempt $23,700,000. That was basically a kind of a new look at the Tax Act in the last 10 years, say. Prior to that, it said every individual can only exempt X dollars. So Maryland says every individual can exempt $5 million. But if you're married and you have a will or your plan essentially ends up, let me back up one other second, is the other thing that Maryland and the federal government allows is you can pass unlimited amounts of money to your surviving spouse if you were married with no estate tax. So again, spouse is the favorite of the law. So regardless of what you think about this guy, Dan Snyder, who owns the Washington football team, could leave his wife the Washington football team and there would be no tax. And the Washington football team, I believe the last time I saw it was worth $2 billion somehow. Anyway, but when his wife died, anything that the Washington football team would be subject to estate tax because she's over whatever the federal threshold is, right? So if we dial that down a little bit, I hope this is going to help. Married couple, Loretta and Bob, have $6 million worth of assets. Yay. So Loretta's like, I just won the lottery, yay. Okay, Loretta dies. Loretta's will says, leave everything to my sweetheart, Bob. So all $6 million is in Bob's pocket when he dies. Bob can only exempt $5 million from tax. Because Loretta did no planning in her will, she lost her $5 million exemption. So now we have $6 million in Bob's pocket. He can exempt $5 million. That's where I get the $1 million difference. Does that make sense?
Maybe, but why don't we go on from here, okay?
All right, let's just put it this way. If you have $6 million and you did not plan in Maryland, your kids will, based on my estimate of a 16% tax rate, pay $160,000 to the comptroller in Annapolis.
Right. So for your inheritance tax, you can leave money to your spouse and children and other direct family members, but you can't leave it to your niece or nephew. If your niece lives outside of Maryland, is there a way does that make any difference?
No, because it's based on, and let me back up. I think that you can still leave money to your nieces and nephews regardless. It's just, it's subject to this 10% tax. So,
no, right.
But what happens is it doesn't matter where the niece or nephew lives. It's where the deceased or dead person lived because they died in Maryland. Maryland law imposes this tax.
Okay. If my sister, for example, passes away, can I leave money to her husband, who is not a direct relative of mine, in order to avoid that 10% tax?
Okay, I believe that you can do that, but before somebody did that, I would advise them like they were coming to me, and this is not a shill for business, but I would say I would need to look at the tax laws.
Okay.
Because that's a little bit out, it just needs to be reviewed a little bit, but I believe it can go to brother-in-laws and sister.
Okay. And here's another one about these the documents. If they're drafted outside the state of Maryland, and then you die in Maryland, if they were drafted in New York State, do they need to be redone in Maryland, or do the New York State documents carry weight here?
Okay, so two things. One, there is reciprocity in the country. And what that means is that a will power of attorney medical directive that is validly executed in Maryland or New York is valid in all the other 49 states. However, also that all documents are subject, when I draft documents, I draft them to make them as effective as I can under Maryland law. Same with the New York documents, who drafted by a New York attorney. And there are nuances or differences in each state's law, so they may not be as efficient or effective, you know, from state to state. I mean, I realize, like, if you were to hear a bunch of lawyers talk about it, it'd be like, oh my God, these are like people talking about angels sitting on the head of a pin, and I get that, but that's the whole thing, is to make them efficient in that state. The other thing is powers of attorney medical directives are really state specific, so they really might not be, while they're effective, you could run into roadblocks with them. And I think with those, I think it's more imperative, because look, you don't want to be holding your medical directive up to your doctor going, you know, well, my spouse needs this, and he's going, I've never seen this document before. What is this? You know, and that is not the time to test whether they will, you know, in a medical emergency, you don't want to worry about them, whether they'll accept the New York document or not.
Right.
And I do, I suggest that clients review their documents the earlier of every 5 years or a major life event. So moving, major life event. And so when I have clients move somewhere, I say, look, you know, once you unpack, find all your lost socks, find the, you know, golf club you're joining or whatever, go see a lawyer, have them review them, and probably redo them for that new state.
Okay. I think we've got a bunch more that have come in recently, but I have one more that came in while you were talking.
Okay.
Pros and cons of leaving money to a charity through a donor-advised fund.
I mean, I think that's up to the person and whether they want to, you know, take that under the, you know, with their advisor and take that under consideration or not. But it's certainly there's certainly a tool to do that.
Okay. All right, this is different. What's the best advice for an adult child to broach the topic of estate planning with a parent who's still capable but quickly deteriorating?
Now, the flip part of me would say bang your head against the wall. No, I think you need to, I don't know, you know, I think it's just, we have to talk to them and say, and I know it's hard, Mom, Dad, we need to do this. I mean, it may help, you know, if you can maybe even make an appointment with the lawyer. I know I probably just broke some ethical rules there. I shouldn't have done that, but you know, I think it is difficult to do that. But if you say, hey, you know, this could be a problem if you won't do it, you know, and maybe if you have the peer pressure, like, you know, ganging up all the children on the parent, maybe that helps a little bit.
Mm-hmm.
I'm sorry if that's not a good answer, but that is a tricky one.
Are there a list of things that don't go to probate?
So, yeah, so the things that don't go through probate are things with, so what goes through probate is anything that is in your own name. So if you have bank account, house, stock, bonds, mutual funds. What doesn't go through probate are assets that are owned jointly. So if you take a husband and wife, you know, bank account that's owned Bob and Loretta doesn't go through probate. Things with designated beneficiaries, life insurance, retirement money is typical of that. And assets in a trust do not go through probate. Now I want to back up because that reminded me of something like, so if you're married, you probably own everything jointly. That's great. If you are single as an adult, a widow, or just, you know, without children, resist with every fiber of your being to put your children's name on anything that you own. Do not put that on your investment assets or your house, God forbid, or anything else. And here's why. And everybody's going, why would this is a problem? So the thing is, as soon as you add your child to an account that you have or your real estate, guess what? They now they have ownership interest in that account or property. So if they own the property with you and they say, look, properties and values in University Park and Hyattsville are through the roof. Let's sell it. they could actually kick you out of your house, the house that you own and paid for, but you put the kid's name on it. So tough beans. The other thing is take your bank accounts. They can go in there, they own it, they can pull money out, go to Tahiti, provided we can travel to Tahiti at any point. So you want to avoid that. The other thing, and I have people come in all the time and go, well, I wanted to do that. And I'm like, well, you need to find another lawyer because I'm not doing it. And then but the other thing is, when I talk to people about this, they say, well, my kids are good kids. They won't do that. And, I wish I had the nickel jar because every time I said that, I would, again, have money to go to Jamaica on. And then, and maybe they don't, and maybe they really wouldn't do that. Here's the problem. Because they own those assets, if they they have a creditor issue. Credit cards, everybody says, well, they pay their credit cards, they wouldn't do this. How about a car accident and they hit a bus full of nuns or a bus full of school children and they have a giant liability and it's their fault? The lawyers are going to be casting around to how to satisfy this debt. You think they're going to care? They're going to take half of that money immediately. They're going to say, well, that wasn't the point. They don't care. They own half of it. So you don't want to do that. And people they think that's a good idea because it does avoid probate. I would suggest that there are the trust will avoid probate. The other thing I would suggest is that there are, in that case, probate versus the risk of your assets, going through probate is the least of your problems at that.
Right. I think you mentioned that you recommend people revisiting documents every 5 years or as a major life event like moving or, some health issues or something like that. So that was one question. The other.
Okay. So so when I talk about that is that when I talk to clients about that is they don't necessarily have to come see their lawyer, but as I tell my clients, placate me from afar. Pull your copies off of the shelf, dust them off. Everything looks good, put them back. You don't have to come see me or anybody else. But if things have changed, because maybe, people you selected to handle your affairs are, total nut jobs by this time or something, you want to look at these. I mean, I'll give you a quick story about that. Years ago, I was handling probate and these two daughters came in who were way older than me. And they came in and they handed me this will, and I could tell that it was ancient. How could I tell it was ancient? It was with that onion skin paper. Remember that stuff? I used to see it, I hadn't seen it since elementary school. And man, this thing is old. How old could it possibly be? And I looked back at the back page and it was drafted the year before I was born. And I wasn't 25 anymore when I went. And I'm like, wow, I'm hoping. It turned out the guy that they picked to be person representative had died. And so, that would have been a good idea for mom or dad to have revisited this will. I don't know, they're suing 20 years or whatever it was, right? So, but yeah, you want to review it just to make sure everything is good.
So you referred to back a while ago to a community spouse, and I have no idea what that means.
Okay, so community spouse, when we're talking about Medicaid, is essentially the spouse that's healthy. It's the spouse that's living at home in the community.
Okay. So I think I got confused about what you were saying about Medicaid's, about what's protected for under Medicaid.
Okay,
that
so
does not have to give up all of their income.
There are ways to protect property for that spouse so that he or she is not looking at still being healthy and living at home or living in the community and being down to their $2,500. There are ways to stop the drain of money to the nursing home from the marital assets.
Okay, great. The last question I have here, and if people have other questions, please put them in the chat now. I don't see a slide here that has your address and phone number on it.
Well, there's my phone number right there. It's the last slide.
Okay, there it is. And just a reminder to everybody, these slides will be going up on our website, on the Hyattsville Aging in Place website, and also the Helping Hands University Park website when we're finished. So It may take a day or two to get them up, but they will be there and you can get to them. Are there any other questions? Oh, there's a new message. Let's see what that is. Oh. So it's helping and clarifying. The website for University Park, Helping Hands University Park is helpinghandsup.org. And for Hyattsville Aging in Place, it's hyattsvilleaginginplace.org. And I think that's where I think that's the question. So if that is the question, so let me just go on to say, this is one of several programs that Hyattsville Aging in Place has done with University Park, but we are opening up a series of programs called Corridor Conversations, which involve the villages up and down Route 1. So the College Park Village, neighbors helping neighbors, College Park, Explorations in Aging, College Park, Hyattsville Aging in Place, of course, and Helping Hands University Park. We're starting a monthly program. The first one is on Thursday, February 25th. It is about the formation of the African American community in North Brentwood in 1987. In 1887. And some of the things that that community has experienced over the period of time that it has been in place. We will have Gabrielle Greaves, who is the education coordinator for the Prince George's County African American Museum and Cultural Center, as main speaker, and also I believe probably the mayor of North Brentwood, but we don't have that confirmed yet. So that is in February 25th. It's at 2 o'clock in the afternoon, Thursday. In March, we are doing a session with Carol Pearson, who was in University Park and now is living in another town in Maryland, about what's on the book that she just recently released on myths and patterns in your life, and basically what stories are you living about. That is on March 31st and at 2 o'clock as well. That's a Wednesday. And in April, we're doing something on Shakespeare, on Macbeth. And if you saw the article in the paper on Janet Griffin, who is the longtime artistic director at the Folger Theater, she'll be doing a presentation talking about what goes on behind the scenes to bring the plays to you, and we'll be looking at part of that Macbeth program. There are more, we will be doing this monthly. That's on the 24th of April at 2 o'clock, that's a Saturday. There are more, we're trying to do these monthly, and we'll be putting the information out soon. So we've got all of your emails, and we'll be sending, or telephone numbers, we'll be sending information fairly soon. And I don't see if there was just, oh, there's another question here, Julie, just a minute. I'm looking for it.
Okay.
I can say, does Maryland have QITs? And I'll just add, what are QITs?
Are they talking about qualified investment trusts?
Oh, maybe. Does the person who asked that want to unmute and say if that's what you meant? You should be able to unmute.
Wait, another message.
Let's assume that is what it is.
Yeah.
I believe so.
Okay.
I have not done one, but I could, I believe they do have those.
Okay. Julie, do you have a website? People are asking, and what we've got here are your phone numbers.
Sure. My website is www.jasestate, that's ESTATELAW.com.
Okay. We may add that, or maybe we can update that slide.
Sure.
So it's on the last slide. That would
Sure.
Yeah.
And if anybody wants my email, it's
Oh, there it is. Thank you, Carter. Carter just posted it to the chat.
okay.
You don't know, you can download the chat by just going to the more button at the bottom of the chat, and it allows you to download it to, and of course I can't find that now, but it's not doing it.
All right, while Lisa looks for that, so regarding the QIT to shelter money to qualify for Medicaid, I guess that's clarifying what they are for anybody who doesn't know.
Gotcha. Well, I know that with Maryland, trust, it's not that they're not favored, but we don't seem to do a lot of that kind of planning with Medicaid with trust, but we do a lot with like annuities for spouses and things like that. So I don't know that they're as favored in Maryland.
Okay. Is there more on that, Loretta?
No, that was it.
Okay, so Carter put the website up on in the chat box. You can save what's in the chat box by going to the right-hand side. There's something, 3 dots, and right at the very top, it'll bring a drop down. It says Save Chat, and that will save the chat. So you've got all of those questions, and you have the additional information that we put in there. I think that's it. So the next time we will be getting together will be on February 25th at 2 o'clock in the afternoon, opening at 1:30. We'll be sending information out. Thank you, Julie, so much. Thank you, Loretta, and thank you, Carter, who has been talking on this program as well.
Well, thank you all very much. I really appreciated the opportunity.
Julie, it was wonderful. Thank you so much.
Thank you.
Thank you.